All right, hello. Sorry, I'm running a little late here because I was working on stuff.
So before we start, there's something I do want to talk to council about at sidebar.
And I didn't need to be on time anyway, it looks like. Sidebar. Well, didn't miss anything, did we? Should have known that was coming. Should have known that was coming. I was trying to work on stuff because I have so much to work on. That's okay. It's okay. We're here. We're here. Hello. Welcome back. And we're back. Suzanne said, where am I talking from? Where are you talking from? Is this a trick question? Is this a trick question? And we're walking to the... I almost didn't come back. I really need to get stuff done. And then I was like, well, we've come this far. But I do really need to get stuff done. So if you hear me clicking, that's why. So this is charge conference. So they're going to be doing the discussions about the jury instructions.
You are unmuted.
All right, so the charge conference, the first question I have is regarding I'll go through them in the order that I have them in my very rough draft, but there's no request of the lesser included offense of voluntary manslaughter to the second degree murder charge. Is that what the Commonwealth's intention is, not to request an instruction on voluntary manslaughter as a lesser included of the second degree murder?
I'm sorry.
Oh.
That's correct, Ron.
Okay. And neither side has requested an instruction of a lesser included of OUI?
It's correct as well.
And the defense is not requesting that?
That's correct, Ron.
Okay. All right. So...
Interesting.
All right. So the first instruction, the request from the defense is that I split the charge, and it's written that way. I'm not going to split the charge. So the way it'll be is the defense will argue first, then the Commonwealth, and then I just go through all the instructions. So aside from that, the first instruction is presumption of innocence. I have one that I typically give, but I will give the one that's requested by the defense. Next instruction is our reasonable doubt instruction. Then function of the jury, the arguments of the lawyers and the judge's comments, function of the judge, functions of the lawyers. Verdict must be based on the evidence. I've incorporated some of what you've both included into that. I have language here that similarly, as you review the exhibits, you may find that some information has been removed because it is not relevant. Please ignore that and don't try and guess what may have been removed or why. I think that came from the defendant's request. Any information that you may have read, heard, or seen about the case outside of the courtroom is not evidence. My instructions to you and any comments I made, the lawyer's opening and closing statements, and any comments they may have made are not evidence. Answers that I struck from the record and told you to disregard are not evidence. Only the testimony of the witnesses, that is, their answers to the questions and exhibits, are evidence, with a more robust instruction, but that's what I've added. And I do have a line about sympathy. Then I do the view. I should say right off the bat, I am not going to give a Bowden instruction. You can argue it. You've been able to put in a tremendous amount of evidence. I've given you a lot of leeway with that. But there is something in this case that and I'm fully within the law to do that. So I have here some language that I think is appropriate based on issues that were raised about the credibility of witnesses. Did the witness have any bias, reason, or motive to give false or shaded testimony? If so, you may consider that bias or motive in your deliberations and ultimately as to whether or not it impacts the credibility of the evidence presented. So I cover the bias part of that. And we'll go through and you can tell me, who's going to argue this for the defense?
I am.
Okay, so we'll go through and we'll do each one. The limiting instructions, I give the defendant's bad acts instruction. I'll give a similar instruction on the digital evidence that I did during the trial, photographs and testimony with an emotional impact, humane practice, and as of today, hypothetical. I had hoped that both of you could suggest something. I said that this morning. Do either side have anything for me on hypotheticals?
I'm sorry, I don't, Your Honor. We're going to be getting back at a fairly early hour. I'm happy to work on it.
That's fine. I mean, I can do it, but I wanted to give you both the opportunity. Yeah, go ahead and do one and send it to me.
I'm happy to do that.
I'll have one to you by the end of the day.
Okay, thank you. All right. Opinion testimony, evaluation of exhibits, direct and indirect, and circumstantial evidence. So I received today defendant's request, a late request for, the law allows both direct and indirect evidence, and there is no distinction to be given. A conviction, however, may not be based upon the piling of inference upon inference or on conjecture and speculation. I don't think that's exactly the language from the case law here that you've cited.
I actually quoted it, Your Honor.
So from which one? From Haunch or?
From Hodge. Hodge quotes McCormick, and McCormick takes the law from Dusty. There are
Yeah, so,
multiple cases that
right, and the language that is typically given on this piling that I haven't really seen in years is you should not pile inference upon inference until the pile gets so high that it tips over logically or the chain gets so weak that it doesn't hold together anymore. When you run through your inferences, check the starting point and the ending point to make sure they're still reasonable. I mean, I can give that old language. All right. That's,
prefer that.
I haven't given that in years, but I'll give that part of it. And just to finish off that paragraph, when the evidence tends equally to give rise to either of two inconsistent propositions, the Commonwealth has established neither proposition. In order to convict the defendant, you must find that all the evidence and reasonable inferences that you have drawn taken together prove that she is guilty beyond a reasonable doubt. Okay, so that rounds off that. All right. All right, so now we'll talk about the, and just to finish off that paragraph, when the evidence tends equally to give rise to either of two inconsistent propositions. The Commonwealth has established neither proposition. In order to convict the defendant, you must find that all the evidence and reasonable inferences that you have drawn taken together prove that she is guilty beyond a reasonable doubt. Okay, so that rounds off that. All right.
Sorry, that sounds better. I didn't like the audio on that one.
All right, so now we'll talk about the indictments and the lesser included. So the second degree murder instruction that was provided by the Commonwealth and the one provided by the defense are just a little bit different. So if you take what was provided, there's one section that the defense incorporates that I think is missing from the instruction, and I'm going by the SJC instructions. So when you get to the second element of second degree murder, the defendant intended to kill John O'Keefe, the second element, first prong. So the second element is that the defendant intended to kill John O'Keefe. As you can see, the second element has three sub-elements. I'm reading from the Commonwealth's proposed instructions, which I shall call prongs, and the Commonwealth satisfies its burden of proof if it proves any one of the three prongs beyond a reasonable doubt. The first prong is that the defendant intended to kill. Now here, I am going to insert, because if you go back to the SJC instructions, I think it is appropriate to go back to the instruction on deliberate premeditation, which is the second element of that, is the language that is offered here by the defendant, that the defendant consciously and purposefully intended to cause the death of John O'Keefe. So who's arguing this for the Commonwealth? So Ms. McLaughlin, does that make sense there?
Yes, Your Honor.
Okay, so I am going to put that in there. All right. And the defense has the language of accident there, but Mr. Yannetti, that really goes at the end. That goes, as you'll see if you look at the instruction on extreme atrocity or cruelty, where you have to go. So that'll go at the end. That will go after the third prong definition. Then I will include the language that I think the Commonwealth put in its request. It goes there. If you have a reasonable doubt as to whether the victim's death was accidental because the death was caused by a negligent, careless, or mistaken act of the defendant, or resulted from a cause separate from the defendant's conduct, you may not find that the Commonwealth has proved the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have created a plain and strong likelihood. Then you have in deciding whether the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. You may consider any credible evidence that the defendant suffered from a mental impairment or was affected by her consumption of alcohol or drugs. That goes there.
That's fine, Your Honor, with us.
Okay, does that make sense to you too, Ms. McLaughlin? Okay. All right, do you want both the mental impairment or consumption of alcohol and drugs? Do you want to just leave the whole generic sentence?
I think we can, yes. I think that's
Is there any objection from the Commonwealth on that?
I don't believe there's any evidence of mental impairment, but the Commonwealth has no strong objection.
All right, but there's no evidence of drugs either, so do you want it to just be alcohol?
I suggest that would be most in line with the evidence, just to have intoxication under alcohol.
All right, it makes sense to me, Mr. Yannetti, if we focus just on the alcohol, but if you wanted the mental impairment, I'd include all, but,
I would prefer, Judge, just to keep it in disjunctive as
all right, so I will think about this one tonight, okay? Okay, then manslaughter while operating a motor vehicle under the influence of liquor. So, Ms. Giannetti, you have included in the language, what does it mean to be under the influence of alcohol? That paragraph that starts after the third element? Yep.
I'm sorry, Your Honor, is there a page number? I'm just going through my. 9. 9. I have it, yes.
All
Sorry.
right, so you have included, it means that a person has consumed enough alcohol to reduce their mental clarity, self-control, and reflexes, and thereby left them with a reduced ability to drive safely. Where is that language from?
This particular portion here, I thought was from the model instructions. If I'm wrong, then we're fine with the model instructions on this issue.
All right, what does the Commonwealth say?
The Commonwealth's language comes from the model and jury instructions, I believe from the most recent 2024 instruction on intoxication.
And that's not in the Commonwealth's request, correct? That sentence I just read?
On page 5, the third paragraph, it's either a similar sentence or a
Yeah, it's a similar sentence, and I was just having both. It was, a person is under the influence of alcohol if they have consumed enough alcohol to reduce their ability to operate a motor vehicle safely by decreasing their judgment, alertness, and ability to respond promptly and effectively to unexpected or emergencies. So we don't need both, Ms. Giannetti?
I agree, Your Honor.
So you have both, so I'm just not going to do that,
We're perfectly fine with that.
okay? So under the second theory, so the Commonwealth is proposing the theory of the .08 or greater. The evidence supports that. I'm going to do that. So in the language from the Commonwealth, the fourth element, now then we talk about wanton and reckless. So for the fourth element, Ms. Giannetti, this is where your language. You have language for 5 that actually belongs in 4, I think. I'm just going to find it. On the foreseeability, I think that belongs under 4. And that's where I'll have it. Okay? Belongs at 4 instead of 5. Do you agree with that, Ms.
I see the language now. Yes, that's fine.
Okay, do you agree with that, Ms. McLaughlin? It belongs under 5?
yes.
Okay. All right, so I'll keep it, it belongs under 4. I'll keep it at 4 and not have it at 5 where you put it, Ms. Giannetti, okay? All right. I am going to give the lesser included offense of involuntary manslaughter. So there's additional language that I have found helpful in other cases. When I discuss the language and the cause of death, remember, Ms. Reed caused John O'Keefe's death if her actions directly and substantially set in motion the entire chain of events that produced the death. And then the next sentence is, a defendant's act is the cause of death where, in a natural and continuous sequence, results in death and without which death would not have occurred. Okay, so those 2 sentences I find go better together, Ms. Giannetti. Is there any objection to that?
No, I understand the question.
Okay, any objection from the Commonwealth?
No, Your Honor.
So, Mr. Yannetti, you have in here a police officer's opinion about a driver's sobriety, like that testified to in this case. A police officer didn't testify as to the defendant's sobriety, so.
I think you're right.
So, okay, so that paragraph that begins with that, we'll just cross that out.
I think that's fine.
Okay. In this same instruction, I have included in the paragraph, in deciding whether the defendant knew or should have known her conduct created a high degree of likelihood that substantial harm would result to another. Some portion of the sentence that I'm going to think about tonight, I have, you may consider any credible evidence that the defendant suffered from a mental impairment or was affected by her consumption of alcohol. Okay. Any objection from the Commonwealth on that?
No, Your Honor, that was requested by the Commonwealth, if you could consider it, please.
Yep, so that will be in that last paragraph of that offense, Mr. Yannetti. Okay, then the lesser included offense, motor vehicle homicide, felony, OUI, liquor, and negligence. I'm going to give that. So I don't have anything because you didn't, the defense didn't propose any lesser included. So I didn't see anything that was inappropriate about the Commonwealth's instruction, Ms. Giannetti. I've added, I think, one line that a person acts negligently when she fails to use due care. That is, when they act in a way that a reasonable person would not act. This can happen either by doing something that a reasonable person would not do under the circumstances, or by failing to do something that a reasonable person would do. It's obviously the law, right?
Right, that's the law of negligence, and I do understand the law of lesser included, and, you know,
Okay,
right to give that.
all right, thank you. So leaving the scene of an accident resulting in death. So what the Commonwealth has provided is basically just the six elements with nothing further. They're pretty much, 1 and 2 have already been defined for the jury many times at this point. 3, the defendant knowingly collided with John O'Keefe. I think that's self-evident. So, Ms. McLaughlin, why don't we start from here? Why did you just give me the 6 elements?
Your Honor, as you suggested, the first 2 have been defined extensively for the jury, and I believe the other 4 prongs are self-evident, and they don't need further instruction.
Yeah.
I think it would be sort of redundant or unnecessary to explain to a juror, what failure to provide documentation of registration and things like that does not warrant additional instruction.
Do you think they need to listen to me any longer than necessary, Ms. Giannetti?
We're in complete agreement, maybe for the first time in this case.
All right, so we'll just leave it. You've offered 6, 2 pages or 3 pages of definitions, so we won't do that.
It's fine.
Okay. All right. Ms. McLaughlin, the use of a dangerous weapon, a motor vehicle, I agree that's an appropriate statement of the law. Tell me about your request to have that.
Defendant's state of mind, also it would go to any intent or any understanding of the jury of what would be reckless conduct or negligent conduct or intentional conduct. If they understand that the use of a motor vehicle to commit a crime could be a per se dangerous weapon, and in using that to strike an individual, that could be used in their deliberations, assessing the defendant's intent or state of mind at the time of the collision.
It seems to make sense, Ms. Giannetti.
My position is it's unnecessary, but I'm going to waive argument here on that.
Okay. All right, I think it makes sense, and I'll just leave it sort of as a catch-all at the end where it appears on the Commonwealth's request. All right, so that's basically it. The longest part maybe is the general instructions in the beginning. Anything specific from the Commonwealth that I did not include?
Do you intend to give a consciousness of guilt instruction?
Oh, I'll hear you on that. I don't, but you can try and convince me if you want.
Your Honor, the Commonwealth would put forth that there's been sufficient evidence that the defendant has engaged in actions that go to her consciousness of guilt. There's an inference that the defendant deleted portions of the Ring video, a narrow area of Ring videos that are missing. They begin with Mike Camerano picking up his daughter at 11 a.m. They resume at 5:07 when the defendant backs her vehicle into John O'Keefe's. Then there's a period missing where the defendant shows the broken taillight to Jennifer McCabe and Carrie Roberts, and then the video resumes again when the victim's niece gets picked up. But not only the missing Ring videos, but also the defendant's behavior. What began as testified to from the Dighton police officer, the defendant's father called the Dighton Police Department and requested a ride to the Good Samaritan Hospital due to the weather conditions. He then drove himself to Brockton to pick up the defendant and perhaps bring her home. What they do in the middle of a blizzard is now Dighton to Brockton is half a distance. Then they travel further all the way back to Canton to retrieve the murder weapon. Along with the defendant's brother, they all meet at the victim's residence to remove the murder vehicle and bring it all the way down to Dighton, Massachusetts. That would go to concealing evidence and intentional. There's also evidence of the defendant's statements going to her consciousness of guilt. Within hours after John's death, the victim's sister-in-law calls the defendant, reaches out, wants to make sure she's okay.
Our crash daddy's like that.
The defendant says to her, "I only have to remember the bad times. You'll likely never hear from me again." Erin O'Keefe testified that she tells the defendant, "Of course we are, we're friends." She's never heard from the defendant since. So I think that goes to the defendant's state of mind in the hours after the death. But in addition to the Ring video, I think there's strong evidence of consciousness of guilt to move the murder vehicle within hours of John's death.
Ms. Giannetti?
Well, first of all, with regard to the Ring video, Trooper Guarino, who was certainly no friend of the defense in this case, testified that there was zero evidence that Karen Reed had access or had access anything on that computer, and the Commonwealth utterly failed to prove that she had any access to delete anything. So I would say that that is a red herring. This is the one case, I think, a very rare case where there's much more consciousness of guilt evidence with regard to the Commonwealth's own witnesses than there is with regard to the defendant in the criminal case. With regard to the other arguments, I'm having trouble following.
So the moving the car extra distance during a blizzard, that part of the argument that the Commonwealth made.
Right. I mean, the evidence was that my client maintained a residence in Mansfield. She didn't live at One Meadow. She spent time there. To say that moving her car to her own home, where the police later found it because she was there and picked up the phone and said that the police were coming and she stayed there and they were able to seize the car, that does not rise to the level of consciousness of guilt.
Okay.
And the defendant actually moved her vehicle to her parents' residence, so that indictment, not her residence in Mansfield, which would further support an inference that she was concealing evidence.
Right. Well, even if it's her parents' house, Your Honor, again, if she's no longer dating John O'Keefe because he's passed away, then it makes sense for her to have her vehicle at her parents' house or her own house. And again, it does not rise to the level of consciousness of guilt.
Nor does she stay at the home of her boyfriend to grieve with the family who just lost John. She quickly comes back to the house, brings her family members, goes upstairs for about 20 minutes by herself with her father, and quickly leaves the residence.
There's no evidence that she did anything upstairs or that she had access or the ability to change anything.
Okay. It's a little bit more robust argument than I expected from the Commonwealth, so I'm going to think about this. I'll let you know before closing argument tomorrow, and if I don't instruct on it, Commonwealth's still able to testify to it. Witness pretrial preparation, that came out on both sides. I'm going to give the second alternative. Okay, Ms. Giannetti, I'll hear you on your instructions.
So I believe that we've covered the vast majority of it.
I'll give you the opportunity to argue the Bowden one,
Oh,
just so you can make a record.
sure. All right, let me just pull up. And I just have a moment. I'll put that document away. That's the quick simple.
I'll find your page.
Okay. Okay, so, yeah, I mean, with regards to the Bowden evidence or instruction, Your Honor, you know, having done this for as long as I have, it's requested a lot and not given, you know, a large percentage of the time. And I do recognize that the court has discretion to give it or not give it, and that we also can argue this in closing argument.
Right.
But, you know, I think that if there's any case where a Bowden instruction should be given, it's this one. You know, we start with the conflict of interest that existed at the start of this case, and the fact that Michael Proctor was allowed to not only continue with the case, but to be the lead investigator or case officer during the whole pendency of the case, despite his obvious conflict of interest with the Albert family. We then move to the fact that, you know, he never, as a lead investigator, went into the house at 34 Fairview. He never looked around. He never checked for any signs of struggle. He never checked out the basement. He never looked for a weapon that could have been used to do the damage that was done to the back of John O'Keefe's head. He never once asked about Chloe, the German Shepherd, despite the obvious injuries to John O'Keefe's mind. With regard to the witnesses, Your Honor, witnesses were interviewed in a very relaxed manner at their own homes. There was testimony that they were interviewed together, that they were not separated out on numerous occasions. Brian Albert, Cole Albert, Jen McCabe, Matt McCabe, all interviewed en masse. Later, everybody in that group, except for Nicole Albert, was also interviewed at the same time. Chris and Julie Albert were interviewed together. And then we have all this, you know, evidence, the way it was handled, or I should say mishandled. You know, starting with the leaf blowers and the solo cups and things being pictured on the floor of garages, not being properly handled, and the fact that there are no chain of custody laws for the evidence before March of 2022. So I just highlight those, Your Honor, as examples. I believe there's more, but that's the record that I would make.
Okay, so you satisfied you've made a complete record on this?
I do. I mean, so.
All right, but I did include some specific bias language that I read to you early on that sort of ties into this. Okay. So nothing else?
I have one question. The defendant requested a missing witness instruction.
Yeah, you're not.
I've withdrawn that. That was crafted as the trial was ongoing. I didn't know if we were going to have that or
Yeah.
not.
Thank you for bringing that up, Ms.
I
McLaughlin.
agree that it's not appropriate in this case.
Okay. All right. So I will see you tomorrow morning.
The question, Your Honor, is, and I haven't tried with this court before, I don't think. Do you typically send a copy of your instructions to counsel prior to?
If I have it finished, I expect I'll be up late tonight and won't have it finished in time for you tomorrow. I do give 2, maybe 3 copies to the jury afterwards.
There was some question as to the use of chalks for closing argument.
Do you permit the use of chalks for closing argument?
So can we focus on this? So does the defense intend to use chalks?
I'm going to defer to my co-counsel on that.
2,
What do you intend to use?
photographs of the vehicle and photographs of the taillight. So 2 side-by-side photographs of the taillight that are in evidence, photographs of the vehicle, or still shots of the vehicle that are in evidence.
Okay. Okay.
And that's the extent of it for me.
Okay. Commonwealth have any objection?
No, but the Commonwealth also intends to use chalks.
What do you intend to use?
Also side-by-side photographs and video, but also a timeline that summarizes text messages and voicemails and significant events from January 28th through January 29th.
Okay. Any,
The request is I'd like to see that.
sure, you should both exchange them, okay?
Judge, my other question is that at one point during the trial, there was a changing of two jurors, their seats, just for purposes of their own comfort. The way I pick alternates is by seat number.
So I'm going to ask you not to pick them by seat number, Jim, by juror number, juror card number. They may
Okay.
not remember what that is.
No, I have absolutely.
No, they may not.
Okay. They may not know their old juror number?
Their actual 3-digit number.
Right, they may not know that? But you want me to use it?
No, if they know it, we'll use it. We'll talk about this.
Okay,
All right. Why did you want to move them into, we'll talk about this.
okay.
All right.
When is that done?
At the,
At what point?
at the end of the instruction, before I give the instruction on be fair, the SJC instruction on be fair.
Well, okay, and we're done. Alrighty. That's it. That's it, y'all. That's it. How are we feeling? What are we thinking? It went quicker than I thought to, but that's good. I mean, because we'll have to sit there and listen to her actually read them to the jury tomorrow. So openings are tomorrow morning. Not openings. Oh, Jesus, no, don't start us over again. Not openings. Closings. Clothings are tomorrow morning. What's our next case so we can start researching? Okay, so I've seen all of y'all talking about it today. We've talked about it in here a little bit. I have mentioned before that that I was looking into covering some of the Sandra Birchmore stuff because it's a lot of the same people, and so many people have asked me to cover it. So I told y'all I would do that. I don't know how many. I've only looked into it, kind of like surface level, obviously, because I've been so busy with this one. But I have said that was, potentially going to be the next one. I still have one the one that I was originally going to do my deep dive on. I'm still planning on doing that one, but it's in the process of an appeal, and so things are iffy on what all I can go over and expose with the appeal pending. As far as like live streamed trials, I'm talking about Sandra Birchmore for the podcast. As far as live stream trials, I'm not sure yet. I need a break. I need a break. This trial has almost killed me. I need a break. I need a break. So, I'm going to take, I had said I was going to do this one if I could get, the schedule worked out. We've talked about this one on stream before. So, I may do that one. I don't know. I'm not going to say one way or the other exactly what I'm going to do yet for sure. That is one that I've had on the calendar. It's one we've talked about before. But Doberman is another. Oh yeah, Doberman's another one too. And I said, like, I'm only going to be able to cover that one if I'm emotionally in a place where I am physically able to, or emotionally, psychologically able to cover it. But Sandra Birchmore was, the pathologist changed the ruling. I posted it on my Twitter. But the pathologist says that the findings contradicted the medical examiner that said that she died of suicide. So I think I'm going to look at that one for the podcast. Doberman is going to be hard. That one is kind of that one's going to be hard. It is one that I've covered as far as the pretrial stuff goes, and it happened in Claremont, Ohio, like Batavia area, and when I worked in Ohio, like my biggest account was there, and I was there a lot. And so when I heard that, I was like, thought it was kind of crazy and weird and just really tragic and sad. But I'm not sure. I kind of want to cover that one because I want to see justice done for those adorable babies, and just the things he did were horrific. However, because the things he did were because it's such a horrific story, it would be really emotionally draining, and I am already so emotionally drained that I don't know how. Oh, Joyful, you live in Claremont County. So when they built West Claremont High School, that was one of my accounts. That was my biggest account. I sold all the big ads that they have on their scoreboards and all that kind of stuff, and in their gym and all that. I sold all those ads. I did sports marketing for a while. So anywho, I am going to think about it and look at scheduling and see kind of what I'm emotionally capable of doing. I've got some behind the scenes stuff going on right now too. And so it's like, I need to get, when we finish this one, I need to, I'll see I'll see. We'll talk about it. Y'all, tomorrow's going to be a big day. We're going to have closing arguments and then jury instructions, and then the jury will finally have the case to deliberate. Please do not do any cases that Lally might be prosecuting. Oh, dear, they're going to rehome Lally after this. I think they'll rehome Lally. I think they'll rehome him. I watched the TV video. It was crazy. Glad. Oh, yeah, we watched some of it at lunch. They've got all kinds of drama going on. It's craziness. There's always stuff. I don't know what's going to happen after this trial, like with all of that. It's interesting because we've talked about, he'll be like, look, Lally's going to get rehomed. I'm telling you right now, the Norfolk County District Attorney's Office is going to rehome him, and Trooper Paul may or may not get rehomed. you know, who knows? Who knows? Who knows? I think it's starting at the regular time tomorrow, so it should be around, we'll start about the same time, about 7:45 in the morning, 8:45 Eastern, 7:45 my time. It's going to be a big day. We're being rated. Oh, hi. Hello. We're being rated. Hello. Welcome. Welcome. Yeah. Well, see, and that's why I've talked about doing Sandra Birchmore for the podcast next, because it is a lot of the same people, and it's one of those things where it's not, it's not like that math ain't mathin'. So I was glad to see today that they changed it to homicide, because it definitely needs to be looked at. And, you know, they had said that they're doing a FBI probe on that one as well. And so this is something that we've talked about here before, and, you know, talked about doing the next, doing that as the next case on the podcast for that reason. So, so I'm going to look into it, but first things first, I'm going to be taking a break, y'all. I'm going to be taking a break. The ruling came out and it's a homicide. Yeah, that's what we were talking about. We talked about it earlier today. We need to keep the heat on the MSP and go with Sandra's case. Another female victim needs justice. Yeah, that one's really sad too. It's really sad. Dimples. That's my new screensaver. Just kidding. Just kidding. Just kidding. Who got charged? Turtle Boy got charged? In that, what, in that stuff? I haven't kept up with it. Yeah, Madeline Soto case breaks my heart too. Oh, no, not him. Oh, who got charged? I don't know. I've seen that there's some, I saw Sue O'Connell saying that there was some kind of drama outside the courthouse. And then, of course, we saw the videos. Oh, Jill and Jim got charged. She came out grabbing his phone. They hate him. They hate him. Bunch of people hate him. It's funny because somebody just tagged me in something. Some of my trolls now are saying that that I say in private that Turtle Boy ruined this case, but I don't say that in public. I'm like, y'all, how many times have I gotten on this stream and said he ruined this case? Like that the way that he does things gets attention to it. It has definitely got attention to it, but it has ruined people being able to discuss it, because people cannot discuss it, because the people who hate him can't discuss anything else other than that. I've said it a million times. I've said it a million times. You can't, like, and we talk about it all the time, like, you can't have conversation, like, even with the stuff, even, like, look at the Crash Daddy stuff. Look at the Crash Daddy stuff. You are still going to have people that argue with that because they hate him. So look, it's effective. It is effective. That is for damn sure. He got a lot of attention on this case. It is a very effective way that he does things. And there's no doubt about that. You cannot argue with that. He is antagonistic. Yes, but that is his style. That's what he does, and it gets attention on it. And a lot of the attention that it gets, like, people do come in hating him. So then it ruins being able to discuss things with people because they won't talk to you about the actual things. You cannot talk to people without them being like, well, Turtle Boy, blah, 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 blah. I think I posted about that a few weeks ago too. This is not breaking news. He even commented on the post when I said it. So, like, this is not breaking news. These are this is like, we've been here, we've done this, we've talked about this. It's effective, but you cannot talk to people who hate him because they can't talk to you about anything other than hating him. And it has completely ruined discussion in this case. People are seeing a few players going into the Fed building, bet another federal grand jury. Oh, that would be interesting. That would be interesting. I don't have to like TV to think Karen Reed is not guilty. I'm not five. Well, that's the thing, though. It's like, you can't, like, anytime you say you have questions or whatever, it's like all of a sudden, like, it's a cult. You're in a cult. You're a conspiracy theorist. You're not allowed to have questions without being in a cult or having him as your, Lord and Savior. And it's like, people's hatred for him has ruined the ability to have actual conversations. And like that part is not his, fault. Like, if you can't have a conversation with somebody because of your feelings towards somebody else, that's your own issues. Like, that part's not his fault. But it has been one of the things that is just so annoying. Like, to not be able to have any kind of conversations with people without the first thing that's said is like, you're called a cult member. Like, I can look at these things and question them without being in a cult. Cults sound fun sometimes. I like Kool-Aid, but no. I can think for myself. Shocker. Shocker! Oh, my stomach's growling. I forgot to eat when we were at lunch because I was working. You mean this isn't a cult? And Emily's like, what? I signed up for this and this ain't a cult? Give me a refund. Give me a refund. Oh my gosh, I will start my own cult with tractors, beer, and puppies. That's like 3 of my favorite things. Look, you throw a Crash Daddy in there and you can sign me right on up. You can sign me right on up. Sign me right on up. The world has stopped engaging in the art of debate. It has nothing to do with this case. Everything is my way or the highway now. If you think you're different, that's the thing. It's like, I've said this a million times too. Like, it's the thing that's frustrating about this is that so many people feel like you have to either accept this theory 100% or this theory 100%. And I don't accept either theory 100%. And the thing that has been crazy about this is that, I have the people who have been very, very like anti-Karen / anti-Turtle Boy don't hear that. They ignore that. Like, they don't like that. That's just, if I'm not 100% in with Commonwealth, then it's just automatically like I'm a cult and I don't have, any brain of my own and whatever. The people who are like like even some of the panels that I've been on recently, like, you know, that invited me on to talk to them about different things, like, as far as like the ones who are full on in with the defense theory, I've had things in my podcast and I've said things on here that go against the defense's theory, but they are like I've noticed that the extremists are not what we're talking about here. There's extremists who there is no logic. They're just weirdo's going to weirdo. But for the most part, like the people who believe in the defense's theory 100% have still been accepting of me, even though I don't. Like, just the people who have like they're cool with the fact that I didn't buy into certain things. And like even when I said like I don't think Colin had anything to do with it, like I got a few of the extremists that were like, you have no common sense whatsoever. And like, you know, I got some of that, but for the most part, people are cool with me having my own thoughts on the free Karen Reed side. On the, like I said, other than the extremist, but on the anti-Karen side, they're not. It's like, if you don't buy into like, and this is just my experience. This is just my experience. But if you don't buy into that 100%, then it's like all of a sudden you're the devil and you hate, you know, puppies, and like you like punch old people when they're not looking or something. I don't know. Like it's like you're everything bad in the world. And yeet cannons. That was like the best part of the day. That was the best part of the day. He made a cannon. I feel like he and I could be friends in real life. Even though he doesn't have a beard. But who would want a beard? Like, who would want to hide that dimple with a beard? He was adorbs. Adorbs. Now that all evidence is in, can you tell us what your thoughts and opinions of what happened are? You know, I have changed my mind so many times and kind of gone back and forth. I have struggled with thinking like, okay, it would just make things so much easier if I truly believed that she hit him. Because even when I'm thinking in my head like that, that would be the easiest explanation. That would be the most likely explanation. Then it's like every time I convince myself like that has to be the most likely, right? Then it's like all these other things that pop up that's like, okay, that's like, it's not working. That's not making sense to me. And I have changed my mind back and forth a million times during this. I have never gotten to the point where I have ever thought guilty beyond a reasonable doubt. Not once. Not once have I ever thought for sure she's guilty. Not one time. But I have gone back and forth about if I think that that's what happened or what is, you know, what has to be the truth. I've gone back and forth so much. I personally, and this is just me, pure speculation based on nothing. After that, okay, how many times? Oh gosh, I said this earlier. I wish I had the clips. I wish I could find the clips of one of, like, how many, if any, times have I said I thought that she, like, that, you know, they got into this fight and he threw the glass and hit the taillight and that's how the taillight busted. Because to me, hitting the car, you can see that she hits his car when she backs out of that driveway. You can see that. But it did not look to me like it would be hard enough to break that taillight. And I get that that's, you know, that was their theory. I guess it was until this theory. But I would give anything to figure, like, to know what day out of all the bazillion days that we've streamed and talked about this. Like, I would love to have the clip where I've said this about throwing the glass and hitting the taillight and busting it. I've thought that before. As far as everything else, I honestly, I am not going to accuse anybody of murder. But if I were to pick a separate theory that I think would be most likely, I feel like something is so weird about Higgins' Jeep and that plow. And it makes me wonder if, I don't know. It makes me wonder if that could, I'm not saying intentional. I'm just saying, I'm trying to think of the parts of all of this that make the least amount of sense. And Higgins' Jeep is one of the things that makes the least amount of sense to me, and his timeline. And I don't know. The way he teared up when he was talking about the nephew, it felt like, I don't know. Who knows? It's hard to say. He could have even thrown it at her car when she drove off. See, that's what I had said before. Like, I feel like, I've said before, I feel like, because we know that she got mad at him and left him, voicemail hollering at him and stuff. So I thought, okay, if they're hollering, I could see them, him wanting to go in there and party and she's not wanting to. And, they get mad at each other and she's like, shut up, you loser. Whatever. And then he throws the glass at her and it, or even if she is like mad and reversing and he's like right there, like throwing the glass at him. And then and I said before, like, I don't think that based on what I've seen in the evidence, I don't think that he went in the house. I've said that before. My personal theory, one of the theories that I thought had been possible was if something happened, if, he jumped out and tried to run up to the house or whatever, before, when she stopped the first time before she pulled up, if he got out and went up to the house, and then that's about the time Chloe would have been outside. So let's say she did get out of the gate and, came around and jumped on him and he fell back on the steps and hit his head and, something like that. And then she doesn't see this because she's sitting there looking forward or mad or whatever. And she doesn't see this happen and tries to drive off and he's trying to walk out for her. And then his head injury makes him fall or something. And then he is out in the snow. I've thought about different things like that. I've worked through different possibilities in my head, but but I personally don't think he went in the house. I know a lot of people do, and that's totally fine. Oh yeah, you're part of a mob is another. Yeah, we're part of a mob. You are not allowed to question things unless you're in a mob or a cult. There's sadly so many cases of cops trying to help a case and then they ruin it instead. Yeah, this has been part of my thing too. I said this on panel the other day. I said, I don't think, and I've said it in here before too, but I have never thought that there's 100 people in on this big conspiracy. I've said the same thing. I can see where they're wanting, cops are wanting to help a case and beef up evidence because they think that she's guilty and they want to make sure that they get a conviction. And then it ends up causing more problems than it does beefing up a case. So I've thought the same thing. Did he have two glasses? I don't know, because some of the glass that was found did not match the glass that was under him, which is a whole nother headache that I can't work out in my head. I just don't understand how, I've never been able to understand how you can make those injuries come from the, make those injuries line up with the car and make the damage to the car line up with those injuries. I've always had that issue. And I kept thinking when we get to trial, they're going to show us something underneath the car that could explain this. And that's not even that. They tested under the car and there was nothing, no kind of anything that showed up under there. And then, and yeah, just none of that worked. Crazy stuff. We could have a verdict by, depending on how long stuff takes tomorrow. So she's going to give an hour for each closing, and then jury instructions, and then they'll be deliberating. And then we'll be able to take naps. Okay, my next episode, I'm about to get to work on it. My next episode is going to be comparing the experts. So the one that I released late last night / early this morning was the two testimonies and everything from Proctor and Buchanan. So the next one is going to be, so like the last episode was like basically like all of the investigation and the investigators. The next episode is going to be all of the experts. And then we'll see what happens. We're getting close. What sucks though is that I feel like the thing about the experts is it didn't answer questions about what did happen. I feel like it only answered questions about what didn't happen. So it's hard because I feel like we're never really going to know. And that part sucks. And that part's sad. Did they ask Karen about taking the stand? Yeah, when they started the charge conference, they swore her in, which I'm assuming that was why, because they would need to ask her, she has to verify that her attorneys talked to her and that she understands and whatever. It would be the stupidest thing in the world for her to testify, honestly. Like, crash daddies is, like, you leave it there. Like, it was really a brilliant defense that was put up, as far as you have a very likable witness who says that, he didn't see a body there, which honestly just, it confirms what 842 other witnesses said that as they drove by there that they didn't see a body. But regardless, he said he didn't see a body there. And then you had the Dr. Russell, who makes me, as much as I work, makes like me seem like a lazy bum. And all of her experience saying, talking about the dog marks and bites and stuff like that. And then you have, and the Ford Edge, yeah. And then you have the medical examiner who also has a ton of experience. 13,000 autopsies. That's a whole lot, y'all. That's a whole lot, y'all. So 13,000 autopsies, and he comes in and says, you know, this is his opinion. And he didn't overdo it. He said, I'm not 100%. Based on my experience, this is what I see. And then the crash daddies. For me, crash daddies is all I needed. You could have put crash daddies on the stand 784 days ago, and there's your reasonable doubt. What's infuriating to me, though, is think about Lally had access to these reports too. These independent experts who were hired by the Department of Justice, and he had access to that too. And he still put Trooper Paul up there. Who's going to pick a Super Trooper over the trial or the crash daddies? But what do I know? As only one of 3 people who knew your actual thoughts on this, I would love to know what Mama Brandy's opinion is, please. The thing is, I have been very careful to not speculate a lot on involvement of other people. We have talked about their weird things that they do. We've talked about like rehoming phones and butt dials and, you know, stuff like that, because those are things that, you know, that happened that may or may not prove anything, but they look weird. It's just part of it. You discuss these things. I've been very careful not to speculate on anybody's involvement because I don't want to influence or accuse somebody of, you know, I mean, that's a huge deal. Like to, you know, accuse somebody of murder. And it's different when people are discussing it in chat. It's different for y'all because you're not like, it's different when you're having a discussion in chat. Saying it on a platform like this is different, which is why I haven't said anything about it, because I just want to be very careful about that. So I have been very, very careful to not give my theory on who I think is involved or could have been involved. I have said who I think isn't. But when will you tell us? I don't know. I don't know. Maybe we'll do a members only after everything's over, and I'll tell you. I like reading what y'all say. How did his shoe and hat go flying? You know, something that I thought was really interesting too. The whole thing about the shoe. Crash Daddy said if the impact was to the body, like if it's a pedestrian and car impact and the impact is to the body, then you would expect to see the shoe come off, which that's something we've heard in other trials. It's something we've heard, you know, from hit and runs and things like that before too, like in, you know, in different things. But he said if the impact is only to the arm, losing the shoe is not consistent with that. And I thought that was really interesting too. Do you have one theory or more than one? I don't have one complete theory. I have different things that I think can explain different parts of it, but not a full theory. But like I said, I want to be very careful. I give opinions on the situations. I have not wanted to give an opinion on specifics about who I think could be. There's dolphins. Oh, they're cute. Who I think may be responsible if she wasn't. All right. All right, we're going to call it a day. I've got podcast stuff to work on. It's going to be a big day tomorrow. I feel like this is like a long time coming, right? Let's see who is live. We can we'll go raid somebody. We'll just be raiding people. It's crazy that we could actually have a verdict like that soon. Oh no, what just happened? Oops. Oh, I hit the wrong thing. Okay. We'll, oh, Brooke, oh, that's what happened. Baker, you raided me. I was trying to raid you. And then like all of a sudden the thing disappeared and it wouldn't let me. Oh, that's why. That's why. I was trying to raid you and then all of a sudden the thing went away. I was trying to assault you since you're always raiding us. Oops. Dang it. I keep hitting. Okay. Here we go. Oh, and Lawyer You Know is starting. I can't wait to see what he says. He starts in like 5 minutes too. The light on my stove is blinking. I know. I have to. Bear, it still says you're alive. All right, well. Valhalla is live. Wait, now it won't let me do that either. What am I doing wrong? Oh, he's done too? Oh, he's here. Oh, dang it. Both of y'all. Sneak attack. I'm sitting here trying to raid both of you losers, and y'all are here. I don't mean losers. I mean welcome. Welcome. That's what I meant to say. That's what I... That's what I... That's what I... Okay, let's try this again. I'm just going to send y'all a Lawyer You Know because he's about to do the recap and we all end up there watching anyway. So we'll just do that. And then, because I would love to hear what he has to say about the day. All right. So we'll portal over there and then we can watch, and see what he has to say. I was trying to raid, I tried to raid Baker and then I was like, why isn't it letting me do it? And then then he's in here and I was like, oh, okay, that's why. So then I try to raid you and then it won't let me. And then you're here. So it's fine. It's fine. Everything's fine. Everything's fine. All right. I'm going to send y'all over. We're all going to go on a community mob / cult field trip over to Lawyer and we'll see what he has to say about the day. Y'all, tomorrow is so big. Tomorrow's a big day. I'm really excited about this. I feel like this trial is like the trial that never ended. And what, if anything, are we going to do with our lives after this? All right, I'm ending things now. I'm going to skip the outro and all that music, and we're just going to go straight over there. I appreciate y'all. I will see you bright and early tomorrow. I'll get the stream set up in just a few minutes, but I will see y'all bright and early. Big day.